All right, once again, good afternoon, everybody. Thank you all so much for joining. This presentation is going to be Know Your Rights about New York Family Core Basics. It's hosted by Legal Hand, the Legal Hand Call-In Center serving Westchester County, and it's going to be presented by Family Legal Care. With me is Ebony Morel and Jessica Stedmeyer from Family Legal Care. My name is Diego Gomez, and I am the center manager for the Legal Hand Call-In Center. But we're going to start. I'm going to give a little bit of an overview regarding Legal Hand. So Ebony, if you wouldn't mind moving to the next slide, please. Thank you. As we know, low-income families and individuals face complex challenges in life. Legal Hand is here to help individuals and family navigate those challenges. Legal Hand helps with issues that affect people's lives. At Legal Hand, our highly trained community volunteers who are not lawyers provide free legal information, assistance, and referrals to help people resolve issues that affect their lives. We help people in areas such as housing, family law matters, immigration, employment, elderly rights, domestic violence, public benefits, and many, many more. Legal Hand works towards preventing problems from turning into legal actions. Thank you. What makes Legal Hand so unique is that we are neighbors helping neighbors. At Legal Hand, we're always warm and welcoming. There are never eligibility requirements. Everybody's welcome. There are no appointments necessary also. We operate weekdays, evenings, and weekends. Legal Hand wants to make it as easy as possible for people, for our visitors, to connect with us, and our services are always free. Visitors who are community members in need now have access to a resource that can help them navigate critical life issues. Legal Hand also benefits the local judicial system by helping resolve issues before they become legal actions. And our volunteers who are community members have an opportunity to help their fellow neighbors. Legal Hand truly creates mutual benefit for everyone. We could get to the next slide, please. Thank you. Beyond our Legal Hand Call-In Center program, we're always working to engage with our local community in meaningful ways. Legal Hand conducts Know Your Rights trainings and workshops such as this one on subjects like utilities, housing and eviction, family law matters, employment, and many other areas. Legal Hand has also an active presence in the community at major local events like In Your Own Voice, Juneteenth Freedom Festival, Latin Fest, job fairs, senior law days, and many more. We reach out organizations like Family Legal Care and any others like local libraries and hundreds of other community organizations to let them know of Legal Hand and let them know that we're here to help. Legal Hand has a proven model that makes a difference. So we thank you all for joining today. We could get to this next slide, please. Lastly, you can contact the Legal Hand Call-In Center by telephone, by text, via chat, and email. Our phone number is right there. It is 914-425-5483. You can reach us via chat, our website, which is on the screen, and our email is also on the screen. There are no eligibility requirements. Like I said, everyone is welcome. And our hours of operation are on the screen right now, but Monday, Tuesday, and Thursday from 11 to 5 o'clock. Wednesdays are late days. We're open from 11 a.m. to 7 p.m. Friday, we're open from 11 to 3. There's a typo there, I'm sorry. And Saturday is from 9 to 12. That's the Legal Hand Call-In Center. So I'm just now going to pass it over to Family Legal Care. Ebony, Jessica, please take it away. And thank you all so much for joining again.
Thank you so much, Diego. And thank you all for joining today. So I'm just going to do a brief introduction, but I'd like to welcome you all to this presentation and also like to thank Legal Hand Call-In Center serving Westchester County for hosting us today. So my name is Jessica Stadmeyer. I'm the Director of Legal Resources and Community Engagement at Family Legal Care, and I'll pass it over to my colleague Ebony to introduce herself.
Hi, good afternoon, everyone. I'm Ebony Morel. I'm the Community Engagement Manager here at Family Legal Care. Thank you all so much for joining us today, and thank you to Legal Hand for hosting us.
All right, thanks, Ebony. So just a couple of housekeeping items before we get started. So first, if you feel comfortable, introduce yourself in the chat. We would love to know where you're calling in from. If you're from a different organization, we'd love to hear from you. And then throughout the presentation, if you have any questions, you can also put them in the chat. Ebony is going to be monitoring those. And then at the very end of the presentation, we'll be opening up for questions. We'll address the questions that are in the chat. And then if you feel comfortable, you can also unmute yourself and ask the question live as well. All right, next slide. So this is what we're going to cover today. First, we're just going to go over who Family Legal Care is and the services that we provide. Then I'll give a really brief overview of the family court system. And then we're going to turn to the substantive legal topics. So parentage and paternity, child support, custody and visitation, family offenses, and orders of protection. And I just want to note that as we're discussing these topics, all of the material that we're covering today is intended to be legal information only and not advice. So as I mentioned earlier, if you have questions about your situation or just general questions about the law, we encourage you to submit them in the chat or ask them at the end. But you may hear us tell you to contact our helpline to speak to an attorney for more specific advice. And that's because everyone's situation is different. And so what applies to you or to one person may not apply to everyone. Okay, so I'll pass it over to Ebony, who's going to actually give the family court overview.
Thank you, Jessica. All right, so first, just an overview of who we are and what we do. If you're not familiar with Family Legal Care, our story goes back all the way to 1996 when a group of 3 young lawyers fresh out of law school recognized that there was a real need in the New York family court system for people to get basic legal information. And so they set up a folding table in the Manhattan Family Court and stationed themselves there to answer questions and offer guidance to people who needed some help. Over 25 years later, our organization has really grown, but our mission effectively remains the same, and that's to increase access to justice for families in the New York Family Court. Today, we do this by offering parents and caregivers free legal information and advice, as well as easy-to-access resources and technology to help them navigate the family court system here in New York, not just in New York City, but all over New York State. Among our programs is our bilingual helpline. Our helpline gives information about New York family law and family court procedure by phone, live chat, and email. Our helpline is also an entryway to our services. So if someone is interested in meeting with an attorney, for example, which I'll discuss in just a little bit, our helpline associates will conduct a screening to see if the person is eligible for a consultation, and then they'll go ahead and schedule that appointment as well. I will say, though, that often people find that after speaking with the helpline, they get a lot of information and perhaps they don't need an attorney consultation anymore as they know what to do to go forward with their case. So our helpline are really amazing and they can provide people with a wealth of information or point them in the right direction. Our general helpline hours are Monday through Friday from 9 to 5, although we do close from 1 to 2 p.m. every day for lunch. The phone number for the helpline is listed here on this slide, and that's 212-343-1122. But you can also access our helpline on our website. I did also want to mention that our helpline, it is bilingual. Most of our associates are fluent in Spanish and English, and we can also serve other languages through an interpreter service. Family Legal Care also offers limited scope representation. And what this means is that we have a team of staff and pro bono attorneys who meet with unrepresented parents and caregivers for 1-hour consultations. And these can be done either by phone or video call. By unrepresented, I mean someone that does not already have an attorney representing them in that case. The level of support that the attorneys provide during these consultations really depends on the case and the litigant's needs. And by the way, by litigant, what I'm referring to is someone who has a case in family court or in court. Examples of what our attorneys can do during these consultations include providing legal guidance on next steps, helping litigants prepare and file petitions or motions, and advising litigants on how to effectively represent themselves in court. Depending on the case and the litigant's needs, our attorneys may be able to provide follow-up consultations and follow-up support as necessary. If you or someone you know is interested in a consultation, you can visit our website to learn more or reach out to our helpline. It's important to note that we don't have any income requirements for any of our services. So for a consultation, the only requirements are that the litigant is not already represented by an attorney, that the case is one of the types of cases listed here on this slide, and that the case is in the New York State Family Court. We provide consultations on paternity and parentage cases, child support, custody, visitation, and guardianship cases. We can also advise people regarding domestic violence issues and orders of protection as they relate to the issues listed here on this slide. We do not provide advice on divorce cases as those happen in the Supreme Court, not family court. And we also do not provide advice on abuse and neglect proceedings. We also offer over 60 original legal resource guides, which provide step-by-step information on a range of New York family law topics. These guides are available in 9 different languages, and they can be found on our website at the URL that you see here on the slide. We have a new website as well, which really makes it much easier to search for legal resource guides by topic, language, and location. Family Legal Care offers or operates tech hubs in 3 different locations, namely in the Bronx, Brooklyn, and Queens. These tech hubs are offices in or near the courts where litigants can go if they need assistance with technology. So for example, if someone needs assistance logging on to a virtual court date, or if they need to print or submit documents for their court case. As I mentioned earlier, though, these spaces are only available in 3 locations within New York City. However, you don't have to be a resident of these boroughs to receive tech hub services. So if you're ever in the area and you're needing assistance with technology, you're welcome to walk into either of the 3 tech hubs, or you can call or email ahead of time to schedule a tech hub appointment. And the contact information for tech hubs is listed here on the slide. Through our Family Law Navigator tool, parents and caregivers can answer questions about their particular family law situation and are then given a detailed, customized report with next steps that they can take, including links to relevant forms and petitions that they can fill out and then submit to the court. This tool is available on our website, which is the link on the slide. Also on our website, we have links to common court forms, including guided court forms that walk you through completing certain family court forms and petitions. Once you complete the program, it'll generate a completed document in PDF format that's ready to be filed with the court. These are accessible on our website. Link is here on the slide, and these are a really great tool, so definitely check them out.
All right, thank you so much, Ebony. So I just want to reiterate that all of our programs and services are completely free, regardless of your income. And you don't need to be a New York City resident. You don't even need to be a New York resident in the state of New York. As long as you have a case in New York Family Court, you can definitely reach out to us and see what level of support we can provide. And you can always visit our website at familylegalcare.org to learn more. So before we get into the substantive law, I want to lay a little bit of groundwork and give a really brief overview of the family court system here in the state of New York. Next slide. So in New York, the family court hears and decides certain types of cases, such as the ones that you see listed here. The ones in green are the types of cases that Ebony mentioned earlier, which family legal care attorneys can advise on. Remember that in New York, divorce is not handled in family court, it's handled in Supreme Court. And then finally, just know that every county in New York has its own family court. Next slide. Family court in the state of New York is intended to be a pro se court, pro se meaning unrepresented by an attorney. So what this means is that family court is really meant to be more friendly and accessible for people who do not have an attorney representing them. There's no filing fees, and rules are supposed to be more simple. And as you see here, most people, about 80%, do end up going through the family court without a lawyer. So if you're dealing with a family court case, you might be able to get a lawyer assigned to you at no cost. That depends on the type of case and on your income. And we're going to cover a little bit more of that today, but if you have questions, just reach out or put them in the chat. And then know that you do not need a lawyer to start a case in family court. This is the next slide, Ebony. You have the right to file petitions and start cases on your own. Again, this is where family legal care can help if you are trying to go through this process on your own. Next slide. So now I'm going to talk about parentage and paternity, and we'll go to the next slide. So recently there was a new law passed called the Child Parent Security Act, or CPSA. And this law, among other things, expands the definition of a parent to be more inclusive. So for example, a same-sex couple can now file to establish parentage in family court. A lot of people still use the term paternity, so you may still hear that. But for this presentation, I'm going to use the more inclusive term of parentage. And you'll often hear from the court or from lawyers talking about establishing parentage or establishing paternity. And this really means determining or proving who the legal father or the legal parents of a child are. Note that parentage must be established legally before any custody, visitation, or child support issues can be heard in court. And once it's established, parents have equal rights to their child. Next slide. There are 3 ways to establish parentage, which you see here, and we've used Maria and Robert as examples to help understand each of these ways. The first way is through marriage and what's called the presumption of legitimacy. Whoever is legally married to the mother of the child at the time of the child's birth will automatically be considered the legal parent, and parentage does not have to be established in court. The second way is through the acknowledgement of parentage form, or the AOP for short. Whoever signs this form after the child is born will be considered the legal parent. The AOP is a form filled out by both parents stating that the individuals filling out the form are indeed the parents of the child. And typically this form is signed at the hospital when the child is born. And the final way is through court. So if parentage has not been established by marriage or through the AOP, the parents can go to court. If the parties agree that the other person is the parent of the court can issue a court order called the order of filiation. And this is an order establishing legal parentage. But if the parties don't agree, or if there's any question about whether the other person is the parent, they can request a DNA test. If that DNA test comes back 99% positive, the court will issue that order of filiation. And just note that an out-of-court DNA test is not admissible in court. And I just want to note something called equitable estoppel. You see it listed here at the bottom of the slide. This is a legal principle that can be used by the court to prevent someone from challenging paternity. And this happens when a father has held themselves out to be a child's father or acted as that child's father. The court can stop that parent from challenging paternity. It's essentially to protect the child. Equitable estoppel is a really complicated topic and really depends on the particular facts of the situation. So we encourage you to reach out to us or to speak to a lawyer if you want more information about this. Next slide. So now, who can file for parentage? You can file for parentage if you're the biological mother or the alleged biological father. The Department of Social Services can also file for parentage if a parent or a child's caregiver has listed the child on their public assistance budget. The child can file, the child's caregiver or guardian, and the intended parent, which goes back to that Child Parent Security Act. And again, that's the law that allows parents to establish parentage, even if they're not the biological parent of a child, for example, such as in instances of gestational surrogacy. Next slide. So remember, once parentage is established, both parents now have equal rights and responsibilities for the child. And this means the right to file for custody visitation, for example, but also the responsibility to support the child financially. Next slide. Okay, and that leads me to the next topic of child support. Next slide. So what is child support? It's the financial support provided by the non-custodial parent. And what we mean by non-custodial parent is the parent that the child does not primarily live with. And child support covers general expenses like food, shelter, and clothing. We're going to talk a little bit in just a minute about add-on expenses. So these are extra expenses that child support can cover, and they cover things like health insurance or healthcare or childcare. Next slide. Before I get into how child support is calculated in New York, I wanted to go over some frequently asked questions that we get about this topic. And the first one is, how long does child support last? In New York State, child support lasts until the child is 21 years old. And this is different from some other states where child support only goes until the age of 18. We also get the question, will the court decide custody and visitation along with my child support case? And the answer is no. They're really heard by separate jurists and they're separate cases and they really don't impact each other. Can I get a court-appointed lawyer to represent me? Generally, the answer is no for child support cases. The only situation where someone might be able to get a court-appointed lawyer in a child support case is if they are a non-custodial parent and they are potentially going to jail or their liberty is at risk for non-payment of child support. And then lastly, what happens if a child receives public assistance? As we mentioned earlier, when a child's receiving public assistance, the Department of Social Services, or DSS, will automatically start a child support case against the non-custodial parent. Just note though, if you're a custodial parent and you have any concerns about domestic violence, and if you're receiving public assistance, you can speak with your caseworker when applying for benefits. You might qualify for a waiver, a domestic violence waiver that would prevent the child support case from getting started. Next slide. Okay, so here's how to calculate child support. The court tries to base child support off a parent's actual income. And this can only happen if both parties show up in court, and this includes virtual court, and they provide credible evidence, meaning they provide sufficient proof regarding their income, such as pay stubs and income tax returns. And another form of evidence that's required is a form called the financial disclosure affidavit. So I already saw a question in the chat from Chelsea about how courts will determine child support if a parent is working off the books. So if a parent's working off the books and doesn't provide credible evidence about their income, the court can also hear evidence from the other parent. So for example, if you had information about how much the other parent earns, even if that parent's not disclosing that income to the court can consider that as evidence as well. And note too that the child support is retroactive to the day the custodial parent or caregiver files the petition or when the child goes on public assistance. And that can result in arrears, which is unpaid child support, being automatically added to the child support order. So I'll give an example here to hopefully make it more sense. If a custodial parent files for child support, let's say in January, but the court does not issue a child support order until July, so now 6 months have passed, the non-custodial parent may owe arrears for that 6 months that it took to resolve the case. But the non-custodial parent can get credit for any support paid during this time. So it's important, if you're a non-custodial parent paying child support, you should keep good records of the payments that you're making to the other parent. You can submit these records to the court, whether it's Zelle transactions or money orders, and then you can get credit for the support paid. Next slide. And child support is based off a percentage of the parent's income. So this percentage that you see here, so for one child, it's about 17%, for 2 children, 25%, and so on. And that makes up the basic child support obligation. And again, that covers the basic needs of a child, such as food, clothing, and shelter. The court can add, as we mentioned earlier, additional support to cover what's known as add-ons, such as unreimbursed or out-of-pocket medical expenses, childcare expenses, and educational costs. But note that educational costs does not include college expenses. Educational costs is really referring to expenses like after-school tutoring or potentially tuition. But if college expenses are going to be included in the child support order through the court, the parties really have to agree on that beforehand. Next slide. So let's talk about arrears. Arrears, again, are unpaid child support. And the first and most important thing to know is that it's really difficult to change arrears once they are in place. If the arrears are owed to the custodial parent or the caregiver of the child, only that person can forgive the arrears. If the child is receiving public assistance and the arrears are then owed to DSS, then potentially, depending on where the case is, the non-custodial parent may qualify for some arrears forgiveness programs. Those are really offered in New York City, but DSS has other options to try to help non-custodial parents manage arrears. So you can always reach out to the Office of Child Support Services, and we're going to give the contact information for them a little bit later if you have a child support case and you're having a hard time keeping up with arrears. And the other thing I'll note is because it's so difficult to modify arrears, it's really important to file a petition to request a modification of your child support as soon as there's been a substantial change or change in your income. And so let's go into that a little bit more and go to the next slide, please. So to request a modification of child support, you would file, again, a modification petition, and you must also show one of 3 things: that either parent's income has changed by 15% or more, that more than 2 years have passed since the last court order, or that there's been a substantial change in circumstances. Next slide. So here are a few examples of substantial changes in circumstances. There's a change in custody. One of the children becomes emancipated. Either they've turned 21 or they got married or joined the military. One of the parents is now incarcerated, or there's been a change of employment. But it's important to note that modification is not automatic. So for example, if you request a decrease in your child support because you lost your job, the court will want to know the reason why that happened. If the change of employment was due to your own fault, the court may decline to modify the child support. Next slide. And note that the court can only generally modify the order back to the day the petition was filed. So I'll give another example here. Let's say I'm the non-custodial parent and I was ordered to pay child support a few years ago. I lost my job today, but I decide not to file for a modification and I'm looking for a job, and then 6 months go by and I'm still unemployed. I haven't been able to make my payments towards support and I now owe arrears or child support debt. I then decide to file for child support. If the court grants my request, the court will only make that child support modification retroactive to the day I filed the petition and not the day that I lost my job. So the arrears that I accrued in that 6-month period will stay in place. And that's why it's important to reach out for help if something changes and you're no longer able to keep up with your child support payments, because you don't want to fall behind. Next slide. So as I promised, here is the contact information for the Office of Child Support Services, or OCSS. They provide different services such as helping custodial parents file for child support. They can help locate a non-custodial parent. They can collect child support payments. They can also enforce child support payments. And if you are interested in speaking with them, you can call 311 and ask for child support, or you can call their helpline. It's the New York State Child Support Helpline, and the number is listed here, 1-888-208-4485. You can also email them, and if you already have a case number, we would just recommend to include your case number in the email. Next slide. So to wrap up child support, just keep in mind that a parent has the right to visitation even if they are not paying child support. And remember, that's because these are separate cases. Next slide. Okay, so now I'm going to talk about custody and visitation, and we'll go to the next slide. So custody is the right to parent your child, and there are really two categories of custody. There's physical custody and legal custody. So physical custody is who the child is primarily living with, and legal custody is about major decision-making. And then visitation is parenting time between the non-custodial parent and the child. And next slide. Just keep in mind that if there's been a history of domestic violence between the parties, the court will take that into consideration and can order parenting time exchanges to take place at a public space, for example, or for there to be limited contact between the parties. Next slide. So what are the different types of custody? You can see some of them listed here. We have joint custody, and that's really referring to when parents share major decision-making, or legal custody, or parenting time, or both. And then sole custody is really where one parent has the decision-making power and more parenting time than the other. And the courts can also order something called split decision-making, and that's referring to zones of decision-making. So for example, one parent might have major decision-making power over educational decisions, and maybe the other parent makes major decisions regarding religion. Just note that shared custody is the default, so that's what people have when there are no court orders. Next slide. And then there are different types of visitation. Like with custody, what the court orders is really going to depend on the situation and what's in the child's best interest. This is known as the best interest of the child standard, which I'm going to cover in the next slide. As far as types of visitation goes, there could be unsupervised visitation, there could be daytime visits, overnight visits, could be electronic or telephone visits. They could be supervised either by an agency or perhaps a private neutral third party. Sometimes it could even be supervised by a relative. And there could be therapeutic visitation. Again, it comes down to what's in the child's best interest in the particular circumstances of that family. So if you go to the next slide, these are the best interests of the child factors that a court will consider when determining issues like custody and visitation when there's no agreement between the parties. So the court will consider factors like who can provide stability and continuity for the child, who has been the child's primary caretaker, what the quality of each parent's home environment is like, both parents' abilities to provide for the child's emotional and intellectual development, any mental health or substance abuse issues. And depending on the age of the child and the maturity, the child's wishes could also be a factor the court considers, and then really any other factor. Next slide. As far as who can file for custody and visitation goes, it depends. So for visitation, Parents can obviously file for visitation, but also grandparents and siblings can file for visitation. They would just have to show that there's already an established relationship between them, that there's a reason why the visits are not happening with the child, and that the visitation would be in the child's best interests. And as far as custody goes, a parent can file for custody, and also anyone else, a non-parent caretaker can file, could be a friend or a relative. They would just need to show that there's extraordinary circumstances, such as abandonment or neglect, and that them having custody would be in the child's best interests. Next slide. So just to go over a couple of FAQs about custody and visitation. So the first we get is where to file for custody and visitation. And generally the answer is you can file for custody or visitation where the child has lived for the past 6 months or more. If the child is younger than 6 months, you can file where the child has primarily lived. How do I change my custody or visitation order? Like with child support, you can file a modification petition. You must prove, however, that there's been a substantial change in circumstances and that the modification you're requesting is in the child's best interests. As far as enforcing the custody and visitation order goes, you can file a petition called a violation petition or a petition for enforcement. Just note that a court cannot force a non-custodial parent to visit with the child. That's something that sometimes comes up. And the last question is, can my child testify in court? The answer is generally no. The court instead would appoint a lawyer for the child to represent them and to report back to the court about what the child is requesting. Next slide. Just know that in a custody and visitation case in New York State Family Court, a parent can request a court-appointed lawyer at no cost. To qualify, the parent must meet the income requirements, which for a family of 2 is a little bit below $46,000 last time I checked. Next slide. Okay, so this is our last substantive legal section, and then we're going to open it up for questions. But first, I'll talk about family offenses and orders of protection. And next slide. In New York, you can obtain an order of protection either in family court or criminal court, though the requirements for each vary. In family court, to get an order of protection, you would need to file a petition called a family offense petition. And to file this petition, you must meet one of the categories listed here. Be related to the other person by blood or marriage, be married to the other person or have been married in the past, have a child in common with the other person, or you were in an intimate relationship. In criminal court, there does not have to be that special relationship like in family court. However, there must be a criminal case, and the prosecutor, ADA, is the one who brings the case to the judge. That's usually after arrest is made. Next slide. Family offenses or orders of protection can impact a parent's visitation. If a parent has an order of protection against them, whether they will be allowed to still have visitation with the child depends on what the order says. If the children are listed on the order, and whether the court decides that visitation would be in the best interests. If you have questions on this, you can reach out to your lawyer or to Family Legal Care for support. Next slide. So these are just some FAQs about orders of protection. The first is, can I file for an order of protection on behalf of my child? And the answer is yes. You can ask the family court for an order of protection or OP that protects you, your child, or both of you. Can my information be kept confidential? Yes, if you have safety concerns about the other parent or the other family member that you're filing a family offense petition from, or that you just have a case against in family court, you can ask the family court to keep your information confidential. There's a separate form that you would typically fill out called an address confidentially affidavit, and it just explains to the court why you're looking for this confidentiality. How long do orders of protection last? In family court, temporary orders of protection generally last until the next court date, and final ones usually last for 2 years, but can be up to 5 years. And then lastly, people will ask, can I get a free lawyer in family offense cases? And the answer is generally yes. If you're financially eligible, you can be appointed a free lawyer to represent you in that case. Next slide. So finally, before we open it up for questions, listed on this slide are different resources for individuals who are victims or survivors of domestic violence and intimate partner violence. We included both state and national resources, as well as some Westchester-based resources. The New York State Coalition Against Domestic Violence also has a directory of additional programs that you can search for by county. And so you can see the link listed there, and you can look for shelters, counseling referrals, and other resources near you. Next slide. And just a reminder that we are here to help. So here's our contact information. Our helpline is really our entryway to our services. And that number is 212-343-1122. Definitely visit our website to access our different legal resources and our tools, and then follow us on social media. And next slide. And we would love to get feedback from you and hear from you on today's webinar. As an incentive for completing our feedback form, we'll send you copies of the slides from today's presentation. So just be sure to fill in your email address. So the feedback form is listed here, and then we'll also put it in the chat as well. And that is it for our presentation. So we're now going to open it up to questions. So if anyone has any questions, feel free to unmute yourself and ask, but we'll also go through the questions in the chat.
We did receive one question a little earlier on the chat, Jess, if you wanted to maybe speak a bit more about this. Someone asked if add-ons in child support cases could also cover kids' activities that the children were part of before any separation.
Yeah, that's a great question. So generally extracurricular activities, like soccer or art classes aren't awarded separately as part of the child support order. They're really intended to be covered by the basic child support order. So in other words, the custodial parent would be expected to pay those extracurricular activities. Parents can certainly agree otherwise. So if you and the other parent agree that you'll split these activities 50-50 or whatever the agreement may be, the court can place that agreement into the court order, but generally they're not considered. And it looks like we just got another question. What kinds of things can be used to show a substantial change in efforts to change legal custody? For example, I heard that the other parent is denied mental health counseling for the kids. So that's a great question. The answer really just depends on the particular situation. So it really has to be something substantial. So a minor change that's really not going to impact the kids wouldn't necessarily be something the court would see as grounds for modification. But if the other parent's denied mental health counseling, that's something you can certainly bring up. It would be up to the judge and take into account that particular fact plus everything else that's going on as to whether a modification is warranted. So you might hear that answer often when you're asking questions about your particular situation. It really just depends, and it depends on what the judge sees and what the judge decides. Because remember back to that slide about best interest of the child factors, no one factor is going to make all the difference in what a judge is deciding. It's really taking into account all the different factors and any relevant factor. And Chelsea, I know I answered your question a little bit earlier, but if you had any follow-up questions about income and how courts consider child support when a parent is working off the books or is claiming no income, certainly feel free to ask, but I'll just kind of go over it again. So even if a parent is saying they don't work and they don't receive any income, the court can order a minimum award of child support, a minimum of $25 a month. But the court won't necessarily accept a parent saying, oh, well, I can't work right now. The court really wants to hear from the parent about why they can't work or why their income is so limited, because the court will operate under the assumption that each parent can earn a minimum living wage or a minimum wage. But let's say a parent was earning $50,000 last year, and now the parent is coming in court and saying, oh, I'm no longer working. The parent has to explain why they can no longer make what they used to make. And if they don't provide a sufficient reason, the court may say, well, I'm going to impute income to you at what you used to make at that $50,000 level. So if the parent has a good reason why they can't work anymore, they really need to bring proof of that. So some parents, for example, they got injured on the job, and so they're no longer physically able to work. If they can provide medical records that are certified and show they can no longer work due to their injury, the court might allow that modification. So I hope that answer cleared up everything. And when I see from Chelsea, the parent does work, it's a pass-through. He pays himself $3,000 a month, but on taxes, it doesn't show up. His income is whatever is left in the business account after taxes. So these are the types of cases where you can really reach out to us for support. We'd happy to talk to you more about that case and kind of give you advice if you met with one of our attorneys on how to present income information about the other parent. So if the parent is hiding income and not disclosing everything that that parent is earning, you can testify as to your knowledge about what the parent makes. The parent will also be responsible for providing proof about how they're supporting themselves, and it'll be up to the court to decide based on all of the income and evidence that's presented. But again, both parents can provide evidence or information, including the form of testimony or documents about each other's incomes for the court to take into consideration. Any other questions? Okay, we just got another question. Do judges take the time to thoroughly read through emails and texts that are evidence of lack of interest in the kids and wanting more time with the kids? So the answer is it really depends. What I always tell people is you want to make this as easy for the judge as possible, because remember that family court judges and support magistrates, they have a lot of cases, and you may not have a lot of time with them when you're going to court. So if there's certain information that you want to make sure the judge sees in a text message or an email, you can do things like highlight that information or maybe point it out to the judge just to make it easy for the judge. Because remember, they may not have time, depending on the judge or their caseload, to read through all the documents presented. So that's really where you can come in and advocate for yourself and make sure the judge hears what you want them to hear and reads what you want them to read. And then we have another question. Can you talk a little bit more about what factors the court considers when looking at if a child is emancipated? And that's for purposes of child support, I'm assuming. So there are certain situations where a child will generally be considered emancipated. So I mentioned a few of those earlier. If a child gets married, a child generally is emancipated. If the child joins the military, if a child turns the age of 21. Those are the general situations where a child will be considered emancipated. A child can also be considered emancipated, for example, if they're over the age of 18 and let's say they're working full time and they're completely financially independent from the custodial parent. Then the parent can make the argument that a child is emancipated and that child support should be terminated. And so that will really depend, again, on the particular factors or particular facts in the situation. So the court really wants to know that they're not receiving support from the custodial parent anymore. They're not living with the custodial parent anymore, things like that. So really depends on the case, but you can certainly reach out to us if you want to talk through your case a little bit. All right, another question. Along the email text line, is it useful to show evidence of the other parent being uncooperative and co-parenting for the purpose of changing custody, or is the behavior just annoying to me but not really relevant to the court? So that's a great question, because the ability to encourage the child's relationship with the other parent is one of the factors that a judge will consider when deciding custody and visitation. So if one parent is not being cooperative and co-parenting or is doing things to actively impact the child's relationship with the other parent, that is certainly a factor that the judge can consider and could impact that parent's right to custody or visitation. And if you make a book of, I'm assuming, of evidence and place tabs or an outline of the page number and the date of the incident, will that help? It certainly could. So I can't really answer for sure because, again, it depends on the case and the judge. But some people find that making a book is helpful for themselves and for the judge. Sometimes people will do like a table of contents and say this is all the evidence. So if you do have a lot of evidence, you want to make it as organized and easy for the judge as possible, because again, remember, they don't have a lot of time with your case. So if you're able to say on page 10 is this, on page 12 is this, and if you look down to line 9 or at the bottom, that can really help a judge versus I have a stack of papers I'm handing a judge and I'm saying somewhere in there is an email I want the judge to read. So we now have a question about what is not a lot of time. I'm guessing that means for not a lot of time for a case to be heard in court and how long to take on cases. So it really depends on the county. we're most familiar with New York City cases because that's where we handle most of the clients. But some judges or jurists in other counties may have more time. And so I couldn't give you a number because it really depends. When I say not a lot of time, I mean, in some cases for child support, you may have 15, 20 minutes even just to present some information depending on where you are in the case. For trials, again, it really depends on the case in the county. So I can't answer that question, unfortunately. Any other questions? So while we're waiting for any last questions to trickle in, just a reminder, if you don't mind sharing your feedback with us, we'd really, really appreciate it. You can go to tinyurl.com, FLC 1017, and then certainly feel free to reach out to us or visit our website if you have any questions at all, or if you need any support. And thank you, Ebony, for putting that URL in the chat. Diego, I'll pass it over to you to see if there's anything else you wanted to say before we wrap up.
No, just wanted to thank you both again so much. This was really great. This was incredibly informative. Thank you both so much for putting this together. I really do appreciate your time. And thank you, everybody who joined us this afternoon. Really appreciate you coming. Hopefully this was informative for you as well. And that's pretty much it. Thank you both so much.
Thank you all. Have a great rest of your day.
Bye, everybody. Thank you so much.